Did Ms. Seidel go down to the fifth floor?
I don't know where she went.
I believe so. I think she was waiting for the victims.
That's what we're waiting for. Everything else is
Here somewhere, where that means I don't know. I'll give him the first part of this.
I think you're If there is any minor, other than Jamarion Lawhorn, maybe can I get a picture of their face? You understand that, correct? We're not waiting for anyone else from your table, correct?
Correct.
All right. You have cell phones, please make sure they're off or in silent mode. All rise, please. Circuit Court is now I will call down Unveiled presiding.
Please be seated.
Good afternoon, Your Honor.
Good afternoon.
We are here today in the matter of Jamarion Lawhorn. Present in the courtroom with Jamarion today is his mother, Anita Lawhorn, his attorney, Charles Bukalu, his guardian ad litem, Judith Raskovich, prosecutor, Vicki Seidel. Also present today are the parents of the victim in this matter, Jared and Danielle Verkerke, as well as his brother, Cameron Verkerke. Thank you.
Thank you very much, Mr. Corey. This is the time and place for the disposition / sentencing in this matter. I believe it was second or third on this. At least 4th of 2015, Jamarion Lawhorn was convicted by jury verdict of first-degree murder. The Michigan court rule that applies to a sentencing slash dispositional hearing in a designated case like this, designated case meaning that a juvenile was designated to be as an adult, as Jamarion was in this case, is found in Michigan Court Rule 3.955A. That particular court rule lists a number of factors, 6 to be specific, for the court to consider in fashioning what an appropriate disposition or sentencing would be in this case. I'll spare everyone the reading of each factor because we're going to be talking about them in depth, and it's all set forth in the court rule. The law is that in deciding what an appropriate disposition or sentencing should be, the court should consider all 6 of the listed factors. But the court is to give greater weight to 2 of the factors. First, the seriousness of the offense, and secondly, the juvenile's prior record. Under the court rule, there is a presumption that a juvenile disposition should be entered, unless the prosecuting attorney shows by a preponderance of the evidence, that is, that it is more likely than not, that based on the 6 criteria, it would be in the best interest of the public to sentence the juvenile as an adult. I've gotten a briefing from both sides in the case, but I'd now like to give each side an opportunity to make whatever arguments they'd like on the applicability of the factors, etc. And Ms. Seidel, I'll start with you on behalf of the people.
Thank you, Your Honor. Your Honor, with respect to our position on this matter, we are asking that the court impose an adult sentence, but delay, obviously, imposition of that, i.e. do a blended sentence in this matter. It's completely our position that a juvenile disposition in this case, one, would not fit the criteria of the factors that the court should consider, and second of all, it would preclude the court from a number of options that you have at your disposal for the next number of years while you determine whether or not the defendant can be rehabilitated in this matter. So that's our basic premise on that, Your Honor. With respect to, I'll go briefly over why we have that position. One of the first factors the court to consider is the seriousness of the offense. You cannot get more serious than what happened here. Your Honor, there's also you're supposed to consider aggravating factors. I would submit that under OV1, the use of a weapon in this case, a knife, it talks about a cutting, is an aggravating factor. So we have that. In addition, Your Honor, under OV4, and when I'm saying OV, I'm talking offense variables for clarification, is the effect, the psychological effect it has on the victims or the victim's family. And obviously, we had testimony. You saw the brother in this case clearly affected, along with his parents, of course, by this matter. So we would submit that that factor completely weighs in favor of an adult sentence, or with blended in this case. Your Honor, the second thing that you look at is how planned out this was. Our position is that it's been planned. The testimony was that he'd planned for a year to kill somebody, and he did it. And he took a knife, walked down to a park, met up with the kid on the way to the park, hid the knife, took the shirt off. All those factors that went into it shows how pre-planned this matter was with respect to him. And we would also submit with that factor under OV10, he chose a vulnerable victim. He chose a young kid. And then he also chose that child, and at the time when the child was in his most vulnerable position, having just come down backwards, like kind of with his back to the back of would be to the defendant, and crouch position when he was stabbed. Your Honor, factor number 3, I'm going to say it's kind of, with respect to that, while he has no adjudications, he had limited contact with the police, he, however, does have some other criminal activity. We know for a fact from the testimony of several people, he started fires on at least 2 or 3 occasions. That's arson. We know that he had a retail fraud. We also know that he, on occasion, would torture mice, which is also shows some torturing of animals, and also that he signed his parents' signature to a document. So I would submit that also weighs in that favor. Your Honor, another factor would be counseling, how he's been with that. Unfortunately, counseling was not given to him, so I guess that factor perhaps weighs the other way. Your Honor, the main things as well with respect to this are factors 5 and 6. and that's the adequacy of the punishment in the juvenile system, and other options available. Your Honor, quite frankly, we just do not know as we stand here today whether or not, if we wait, he's 13 right now, if we wait 8 years for his 21st birthday, is that sufficient? I don't know. And we just don't know right now, and it might not be. He's committed a murder at the age of 12. It's going to take an awful lot for him to be rehabilitated, if he ever can be. And so, in our position, the juvenile system, just by itself, without something possibly hanging over his head, is just insufficient to take care of this matter. And I'm not saying that at some point you don't just say, okay, you get released without going to prison, but that option has to be there in case his conduct in the future shows he clearly is not subject to rehabilitation. Your Honor, for those reasons then, we submit that the factors in this case weigh in favor of that. Your Honor, should you just, as I stated before, choose a juvenile option in this, he can get released to the public by age 21. And perhaps under the facts of this case and circumstances as they exist later, that's just not a good idea. That you would not be able to protect society from the defendant in this matter. So by imposing an adult and delaying it, it clearly gives you options down the road in this case. So therefore, that's their request with that. Your Honor, would you also like us to had with the sentencing, well, unless you have any other questions for me regarding the factors.
Well, let me ask you a question. As you know, Ms. Seiler, the people in this case filed a motion under the statute requesting the court impose an adult sentence of life imprisonment without parole.
That's correct.
I gather that your office's position is that you filed the motion, but you're asking that the court hold it in abeyance as well. Is that correct?
That would be accurate, Your Honor. Even in, I believe, in the motion, we indicated that we know that we don't even ask that that motion be heard or that notice for years. It may never be heard. But I don't think that at this point we should be precluded. As you know, I think the law required that we would file that within 21 days of a conviction. So we filed it. We had no intention of necessarily standing before you today saying we want life without parole. Once again, however, for the same reasons, I want you to have all options available for sentencing at some point. Our office would like to protect its interests in perhaps asking for life without parole at some day. And Your Honor, would you also like this? You also had us brief the issue of whether or not you thought you had a set the time. Do you want me to discuss that issue as well?
Why don't you?
Okay. Thank you. Your Honor, we would submit that you do not have to tell, as we stand here today, should you impose an adult sentence but delay it, that you don't have to set a specific term of years as to what you could do in this matter. I think the law, and we gave you some cites.
You're not going to say it was
That's a
clear
law.
because the
Yes,
law
it's not.
is not clear.
It is not. I can. However, I can state that as written, to me, it clearly indicates that it is a situation where you're taking into consideration, if you have to sentence someone later, that you can take into account a number of factors when you do the sentence. And Your Honor, actually, what's kind of interesting in this particular case is, as the Court of Appeals specifically has said recently, that matter of whether you get life without parole is an issue for the jury to decide.
Indeed.
So we're here before you right now with what I consider three major options, well, four I guess, but three options in terms of what could be done in this case, and which is why I don't think you have to do a set term of whatever it is you might choose to do today or in the future. And for the same reasons I said, otherwise you'll be precluded from all the options that exist. Obviously, you could do a straight juvenile in this case, and then no matter what, he'd be released at least prior to his 21st birthday or on his 21st birthday.
My question that I think I set forth in the order is really one simply of statutory construction.
Okay.
And that is that when the statute, and I'm looking at MCL 712.8.18.1 sub M, it says, quote, the court may delay imposing a sentence of imprisonment under this subdivision for a period not longer than, et cetera, et cetera. And I guess my question is whether when the legislature uses the term sentence of imprisonment, that necessarily implies a specific sentence with a minimum and maximum, or whether that simply means generically if the court ever imposes a sentence of imprisonment down the road. And I read what you filed, and you've got some unpublished decisions that you argue implicitly seem to suggest that that's okay. You would agree there doesn't seem to be any law addressing the issue specifically?
Not on point. We certainly have tried to research the issue. We do rely on some of the other language, because it also says, delay imposition of sentence. It doesn't say of the sentence. And it also, later it says to the court, if you delay imposition of the sentence, let me make sure I get the exact language for you, Judge. It says if you delay sentence of that, a sentence, later it talks about if you later impose a sentence, it can't be greater than the maximum of the sentence that could have been imposed at the time. If they're saying that, that implies to me that you have the opportunity of sentencing up to what could have been at the original time, because that's what the rest of the statute, plain language of the statute says.
Here, of course, that's also further complicated by the fact that there are mandatory minimums and minimum maximums in this case, which is something I'm not sure I've ever seen before, the minimum maximum term in this context.
That's correct.
So you would agree that in many ways a future possible prison sentence, the court may well be handcuffed as to exactly what that sentence would be here, because while the pre-sentence report author for adult probation did not run guidelines, it appeared to be his suggestion that even if he were to apply virtually all of the offense variables that could be applied, it would probably not exceed the mandatory minimum of 25 years. Is that right?
Correct. I think they just follow the statute, which I also quote in here as well, is under the statute for if you're sentencing somebody who's under the age of 18 at the time they committed the crime under a first-degree murder, that, yes, the statute says 25 to 40, that range, and no greater than 60.
I think it's no less than 60.
No less, yes, I'm sorry, yes.
Correct.
So it's, yeah, to the 60. And then, so that's how that statute reads. And so, granted, there's a statutory part in here, but then there also is, even under the U.S. Supreme Court case of Miller, when they said that you can't automatically do a life without parole to anyone under 18, that you have to have a hearing on that matter at some point if you decide to do life without parole. That also complicates this case, and it really got complicated with the recent Court of Appeals decision, which would actually take that decision out of your hands and give it to a jury.
And which I have no problem having just out of my hands in cases like this.
I'm sure.
But the position that your office has taken, which is let's wait and see, we filed the motion, but let's wait and see what happens, necessarily means that I would have to convene a new jury, people who did not hear the trial in this case, people who would not know anything about this case. Does your office envision that if you ever asked me to do that, that we would essentially retry the entire case?
Your Honor, I'm hoping actually that law gets changed by the time that the issue may come back up. But quite frankly, Your Honor, that's what the situation that the state of Michigan finds itself in right now anyway. They're trying to find out if those cases go retroactive, if that decision...
The Supreme Court may make that decision for us all.
Exactly, and then what the point on that is we do have some people presently from Kent County who are convicted of first-degree murder. They're under the age of 18 at the time, who are serving life without parole. Some of them have been in there for years, decades. I guess under what they have envisioned us to have to do, if they say we have to do it, then perhaps we do have to convene a jury for every one of those cases.
I understand that it may not have the identical due process requirements as a guilt phase trial might, but in effect we can't very well convene 12 people and say, you don't know anything about this, but let's present some aggravating and mitigating factors.
Correct.
All right, fair enough.
And so once again, with any respect to any other questions the court may have, I'd be happy to answer them.
I appreciate it, Settle, as always.
Thank you.
Bukalu, let's start with the second part first, because if I understood your memorandum, you share the people's view that the delayed sentence of imprisonment does in fact mean that the court need not render a specific prison sentence today, but rather can wait until and unless someone asks the court to impose a prison sentence. Is that right?
Or if the court sua sponte would do so. But yes, I think that's right. My reading of the statute, specifically I think it's subsection 9, says allowing the court to impose any of the penalty it could have imposed immediately presupposes that there's discretion there. At least that's the way I take it. Otherwise, I don't think they would have used the word could have. Otherwise they would just say impose the sentence that was arrived at the sentencing hearing. At least that's how I read it. And I suspect that that's their intent.
Well, you're talking about the guilty to mentally ill statute?
No, I'm talking about subsection 9 of the sentencing statute. Specifically, 712A.18I, subsection 9.
You're talking about I.
Yes, I'm sorry, I.
Because I'm talking about M. Because M is the statute that deals specifically with a blended sentence. I comes into play if the court adopts a blended sentence. I'm really focusing on the language in M about delaying a sentence of imprisonment and whether that necessarily implies that I will have already determined a prison sentence and then would already have determined it. Therefore, if I'm asked later to impose it, it's already been determined. As opposed to the people's argument, which seems to be, why wouldn't you wait, Judge? Because you'll then have the benefit of whatever time lapses between now and the time that they may ever ask me to impose the sentence. Do you agree with them on that issue?
I do, and I think mainly because there's nothing in the statute that uses the term blended sentence. It talks about delaying the imposition of, and we called it the delay of the imposition. We called it a blended sentence because it seems to make it's better shorthand for us, I guess. But the point is, I think M really isn't different than I on the point. Either way, you're delaying imposition of an adult sentence, whether you consider it a sentence you're ready to impose. If you're delaying it, then you're about...
The question that I need your position on is
Okay.
simple. Do you believe that today I should be calculating and imposing an adult sentence, but order that it be delayed unless and until there comes a time when I'm asked to actually impose it? Or do you believe that I should not calculate anything today, rather wait and see if at some point in the future the people then say, hey, hypothetically, he just committed a probation violation. We're now asking you to impose that sentence, Judge. And then at that time, I would run whatever the guideline calculus would be, whether or not it would make a difference with these mandatory minimums. That's really the question I'm trying to grapple with.
Yes, Your Honor. And I think the answer is I do believe that I do agree with the prosecution on this point.
Okay.
Okay.
That's fair enough. And now, if you'd like to address the factors or anything else.
Well, I do want to touch upon the issue of the request for imposing a sentence of life without parole.
Okay.
I disagree with the prosecution that we can wait ad infinitum until the end of until he's 21 to make that decision. I can see delaying it for, there's no law on it, obviously, it's brand new. But if we allowed the delay until Jamarion is 21, what's the point of the time constraint? I mean, there's nothing in there that really commits them to anything until the end of the potential juvenile disposition. I view it more as an opportunity to maybe have like a typical adult delay of sentence of up to a year or something like that. I don't think that decision needs to be made today, but I don't think it should be delayed and held over his head until he's 21 either. And otherwise I don't think there would be a time limit on making that motion.
So let me say this. I am dubious as to the prosecutor's position on this, that they can make a motion and then say, but we'll decide when and if the court chooses to bring it up. And especially if that's 9 years down the road, 8 years down the road, 7 years down the road. But I also share your view. I don't think it's right, and I'm not ruling out of that.
Fair enough. I won't go any farther with it. Okay, going back to the other issue, which is the factors itself. I'm not going to dispute, and I did in my brief, about the seriousness of the offense. I know that's a clear factor. This is the most serious offense we've got in the books. And with good reason, obviously. I would say that the second factor, acknowledging that there were elements that were sustained here, this is not a situation where we have, there's never been any allegation of evil intent or some sort of motive of anything other than essentially trying to get himself killed. I don't believe, the term planning, yes, he used, the evidence was that he used the word planning a year ago when he had moved, before he moved to New York. There certainly wasn't any evidence of an intricate plan here. And as far as a vulnerable victim, if he's really going after a vulnerable victim, he probably would have chosen one of the other boys. This is clearly somebody who had reached his breaking point, and I don't think there's any question about that.
Well, let me ask you this. I mean, I'm hearing you, and I get what you're saying. Aren't I, in large part, on that issue, bound by the jury's verdict? I mean, they found your client guilty of first-degree murder, and that necessarily meant that they found the elements of that crime beyond a reasonable doubt. And that included deliberation, it included, malice aforethought, it included those kinds of things. I mean, am I really in a position to say, well, yeah, they convicted him of that, but I now have the freedom to be able to say, but I didn't really look at the case the same way they did?
No, Your Honor, I'm not suggesting that the first factor.
No, the second factor.
The second factor is what I'm talking about now. That's the aggravating, what might be aggravating factors. And I'm suggesting that one of the things is the level of planning. I suggest to you there wasn't a great deal of planning here, even though the word planning was used. And it's certainly, I'm not suggesting that that there was not premeditation at this point. The jury has decided that issue. But with respect to the other aggravating factors, it's not as clearly in favor of an adult sentence as I believe the prosecution's saying.
Okay.
With respect to the third factor, there's absolutely no prior record, period. The prosecution wants to suggest that there's arson. There was some evidence that he lit a fire before. Whether that qualified as arson, there has to be a lot more there. She keeps talking about some mutilation of some animal. I don't recall any direct evidence on that point whatsoever in the trial or otherwise to support even the notion, much less the reliance upon that.
It may have been contained in one of the experts' reports. Is that fair game?
That it's possibly there. I think it might possibly be there.
Okay.
I don't think there's enough there to rely upon it for this particular factor.
Okay.
And certainly, was there an allegation that he shoplifted? I think there was. There's never been an admission, but the point is, I don't think there's any serious issue of prior record that would render this factor being anything other than in favor of.
I will say this. I think there is general agreement that he has never been formally adjudicated of a juvenile offense prior to this incident. So my sense is that what we're really talking about is, and of course 3 goes a little beyond it because it says not limited to, and then kind of opens it up, et cetera, et cetera. So, but I don't think it's in dispute that he had no prior record, and in fact, in the pre-sentence report that was prepared, I do not believe it scored any under prior record variable. I think that was 0.
Right. The fourth factor, I think, is clearly in favor of a juvenile disposition here. I mean, we're talking about an individual who's, forgive me, Your Honor, who made numerous attempts to try and get some help. There was numerous references to try and get some counseling. He disclosed things to proper authorities about prior abuse and was never meaningfully dealt with. Part of that factor truly is willingness to participate meaningfully in available programming. I'd submit to you that he did try and do that. I don't think there's any suggestion that he wasn't willing in the past. And frankly, his improvement while in detention shows his willingness to participate in appropriate programming. And even the testimony is his improvement just in that year is evidence of the potential for rehabilitation here and for programming to be successful. And similarly, in the fifth factor, a lot of the same things apply, and I'm not going to go much beyond that.
Okay, very good.
In the sixth factor, there's availability of programming. I'd submit for a 13-year-old here, the availability of programming in the juvenile system far outweighs anything that is available in the adult system to rehabilitate Mr. Lawhorn. And quite frankly, at this point, we'd ask you to consider it just a straight juvenile disposition. I think most of those factors, albeit one of them is not against it, that's the seriousness of the offense. And that's one that you have to take more seriously, as you noted at the beginning. But a collection of all the factors would support a disposition of straight juvenile disposition here, especially looking at the age of the defendant. He's going to be involved could be involved in the system for up to 9 years.
All right. Mr. Moskowitz, you didn't participate briefly here, but I certainly want to give you an opportunity if you'd like. I'm going to give you an opportunity to address the court later if you prefer.
I'll address the court later, Your Honor.
Fair enough. Well, now the court will review those factors as the law requires. First, the seriousness of the offense, first-degree murder, is, as has already been indicated, the most serious crime that can be committed in the state of Michigan. If this were an adult conviction, the sentence in Michigan would be mandatory life without the possibility of parole. The seriousness of the offense here weighs heavily in the balance of factors. Moreover, the aggravating factors under the sentencing guidelines would likely include at least the following: 50 points for premeditation, 25 points for the victim being stabbed with a knife, 5 points for the offender possessing a knife, 100 points because the victim was killed, and arguably additional points because of a vulnerable victim. And with respect to the impact that the killing has had on the surviving family members, I heard the testimony at the trial. It's clear that the family has been broken over this. I hope not irretrievably. But I also suspect that we may be hearing from victims in a few minutes, and I'll allow them to, I won't presume, to be able to fully explain or describe how this has impacted them. The culpability of the defendant in committing the offense, it seems, also cuts heavily against the defendant in the balance of factors. The jury did find here that he acted willfully, deliberately, with premeditation. And the evidence was clear that Jamarion did indicate to the Network 180 assessor that he had been planning to carry out this sort of murder-suicide plan that he had for a year. I don't doubt that that doesn't mean he was obsessed with this for the entirety of the year, but I do believe that he clearly had been thinking about this. And, we had some post-verdict motions that I decided a few weeks ago, and we discussed a number of things in those motions, including whether the court should have given a manslaughter instruction, which I ruled was not appropriate here. And part of that was because I concluded that based on that testimony, it's difficult for the court to conclude that this did not involve some premeditation and deliberation. So I think that also cuts against the defendant overall. I think the third factor is by far the one that is most in the defendant's favor. And that is that he does have no prior juvenile adjudications or adult convictions. He has had, I'd say, average to below average behavior at the juvenile detention facility. I'm getting all of this from not only trial record, but also the experts' reports that were admitted to evidence previously in the case. His mother reported a number of different things, although some of them were clearly not based on first-hand knowledge. Some may have been. His mother reported that Jamarion had gotten into some fights, although there was no indication that I saw that they were of a particularly serious nature. He had been suspended from school on more than one occasion. He had engaged in some stealing behavior. There was also some evidence, though I have to say lacking details, that he may have started a fire at home and possibly abused an animal at some point in his childhood. But the probation officer also has indicated, at least in the past, maybe not the current one because we just got a new one, that Jamarion has also shown growth and maturity since this killing occurred in August of 2014 and since he has been detained for now a significant period of time. With respect to programming history, prior to the killing, he had not been offered formal counseling. While in detention, he participated in and benefited from counseling. Unfortunately, the most recent report is that since he was convicted of first-degree murder, he has withdrawn from counseling, but I am optimistic that he will re-engage after today's proceeding and after his future becomes less unknown. He has stated ideations of and taken some steps towards self-harm or suicide while in juvenile detention. The evidence suggests that over a period of time, some of these episodes have been genuine, maybe some less so, but clearly counseling is important for this young man. The recommended punishment and programming that is available in the juvenile system is a commitment to the Muskegon River Youth Home for some number of years. Muskegon River Youth Home has a section devoted to juvenile murderers. I, as a judge doing this work, have another case with a convicted juvenile murderer who is in that particular institution and in that particular wing, if you will, of the facility. Muskegon River Youth Home is a locked-down, secure facility which will protect the safety of the community from any threat that the defendant may pose. The programming there is intense. It includes schooling, it includes various forms of counseling. It has a tiered system where the juveniles can earn privileges by abiding by the rules and lose them for failing to do so. In that sense, I would say it is analogous to an adult prison, though clearly it's not exactly the same thing, if for no other reason than the age of the offenders. In the court's view, Muskegon River Youth Home would provide adequate punishment and also provide the opportunity for Jamarion to grow, to mature, to further understand the damage he has done through his actions, and to give him the tools to make amends for his wrongful conduct. The dispositional options that are available to the court are threefold. First, a straight juvenile dispositional sentence that could include community probation, commitment to a juvenile institution, or both. Secondly, the immediate imposition of an adult prison sentence, committing the defendant to the Michigan Department of Corrections for placement in a prison. Or three, a so-called blended sentence, where the court would impose an adult prison sentence but delay any imposition pending reviews of the defendant's behavior and progress in a juvenile institution or on community probation. An adult prison sentence, whether imposed or delayed by the court at this time, is governed by MCL 712.8.18, sub 1, sub m. As is indicated in the discussion I had with Ms. Seiler, in this particular case, by statute, a sentence of imprisonment carries a mandatory minimum of between 25 and 40 years. That means that it would be between 25 and 40 years before Jamarion would even be eligible for release on parole, and a maximum of at least 60 years. That is mandatory on the court, that is by statute, that is our legislature's decision, and I am bound to follow that if I were to impose an adult sentence, either today or at some point in the future. The court may delay imposing a sentence of imprisonment for a period up to the time that the court continues to have jurisdiction over the juvenile. If my reading of the statutes are correct, I've done this long enough, but sometimes you don't look at all these statutes, I believe that the typical age of jurisdiction is 17 under MCL 712.8.2 sub a. That may be extended to 19 under MCL 712.8.2a sub 1, and if the crime of conviction is a specified offense that includes the crime of murder, the court may also extend its jurisdiction to 21 under MCL 712.8.2a sub 4. Pursuant to the delayed sentence option, the court may enter an order of disposition delaying imposition of sentence and placing the juvenile on probation upon appropriate conditions, including any disposition available under the dispositional statute, and those dispositional options include commitment to a suitable juvenile institution. I also note that under 712.8.18I1, the court may sentence the juvenile at any time during the delay to an adult sentence. So it is not required that the court wait for any particular time in order to do that. That is what I think the law is, and what I'd like to do now is to give the victims who are here an opportunity to address the court. I'll let them do that however, wherever they would like to do, whatever they're most comfortable with. And to the media that's here, I've authorized pictures and photographs of Jamarion's face because he is now being convicted of an adult crime. But if we have a young person who is speaking today, you not allow any photographs of his face. Well,
Hi. It probably goes without saying that losing Connor has caused irrevocable pain. I carry it every day and I miss him every day. This past year, I watched as my son, who prior to losing Connor brought home straight A+s all across the board, dropped down to C's and D-minuses. His grades are back up. But there are several studies that I have read about what happens to young children who are exposed to severe acts of violence. And these, along with my own grief, keeps me up every night. I feel like I constantly exist in two worlds, this one and one where Connor is still here. Not a day goes by that I don't imagine what he would be doing, wearing, what clever jokes he would make that would cause me to laugh. You know, I picture him sitting in that chair if he had been able to live through it, but he's not there. I don't often address this, and I had to step out, so I'm not even sure if it was brought up or not. But I myself experienced abuse growing up, and after I moved out just before I was 19 years old, not very many people knew about it, even inside of my own home. And when I found out that I was pregnant with Connor, I began researching how to break the cycle, how to be a better parent. I took classes because I never wanted any of my children to feel the way that I felt or to be touched by that. So the notion that he should possibly receive a lesser sentence or not as much time based on his home circumstances hurts because of my own history, and I feel like it adds to the stigma of people who have been abused or have mental illness, and it would be doing us a disservice. Financially, this has caused a big mess. We have spent over $2,500 out of pocket on therapy over the last year, and Cameron will be in and out of therapy well into adulthood because as he grows up and as his brain matures, he is going to have to constantly reprocess what happened. Just all around, this has been completely devastating. And I just wanted to say that I firmly believe in the saying that grieving the loss of a child is a process, and it begins on the day that your child passes and ends the day that the parent joins them. So, thank you.
anyone else?
Yes, Your Honor.
Cameron, how are you?
Good.
I remember seeing you at the trial. What would you like to say?
The way this has affected my life is it's hard to make friends, and sometimes it makes it, and sometimes when I wake up, I wonder where
my brother Connor is, and I remember that was the opposite of a dream. And sometimes it's hard to make friends because they might be like Jamarion. And I miss Connor, like how he was funny. He is the funniest kid ever. I love how he would spend time with me. Jamarion lied and killed my older brother. What does that say? Okay. Connor was my first best friend, and I will miss him forever.
Thank you very much.
To say my son's death hit us like a wrecking ball feels like an understatement. It has wrapped its ugly hand around every part of my life. Still to this day, I am a shell of who I once was. I'm a shell of the man I was on August 3rd, 2014. That is the last full day where my family was whole. That was my 7th wedding anniversary, and we went on a family swimming trip. And now every day I relive the horror of the next day, August 4th. There are no words to explain holding my dying son in my arms, no way to count the trauma of his brothers watching him die. These are the last living memories I have of my son. These scenes replay in my head and make the horror movie seem like a docile by comparison. I say this all not to gain sympathy, but to begin to paint an explanation for what this has done to us. I love my son, and not a second goes by, sleeping or awake, that I do not miss him and agonize for what happened to him.
Thank you very much, folks. It's important for all of us to hear the remarks. I do want to indicate that a pre-sentence investigation report was prepared by the Adult Probation Department. It recommends that the defendant be committed to the Michigan Department of Corrections, but it does not take a position as to whether that sentence should be imposed or delayed. I did find it to be useful for some biographical information, but it did not do a guideline calculus either. I inquired of the probation officer as to why, and he indicated it was his belief that because of the statutory mandatory minimums that it may have been essentially moot, because from my reading of the memos that were filed by the parties, it appeared that there was agreement that the court did not have to choose a specific minimum or maximum. I didn't think it was worth pursuing that, and that can always be done down the road if it is necessary. Now I would like to hear from our juvenile probation officer, Mr. Corey, who did file a report and is also making a recommendation.
Yes, Your Honor. Your Honor, I received this case approximately a month ago, and as you have explained in your statement, my recommendation is going to be the Muskegon River Youth Home. I did contact the Muskegon River Youth Home, forward them the information on Jamarion, and on October 22nd, the psychologist and the program director did interview Jamarion in detention, and they have accepted him for placement if so ordered. Muskegon River Youth Home, as you have pointed out, Your Honor, specializes in treating long-term youth and can provide the treatment necessary to address the previous issues in Jamarion's life, including this tragic offense that has occurred. He will be assigned a case manager, a counselor, and a psychologist during his stay at Muskegon River Youth Home. The psychologist will work with him intensively on a weekly basis and will also provide a psychological report to this court. So I do feel that I too have a youth that's in the long-term program. It's a very positive program. at this point. I think it will immensely benefit Jamarion to be in that program, and he will be there for the long term. Due to the seriousness of this offense, it is clear he has to be in a secure setting, and that, sir, will be my recommendation. So my recommendation is that he continue as a ward of the court. He be placed in a suitable institution, the Muskegon River Youth Home, that he continue to reside in detention pending that placement, that he participate in counseling, attend school regularly. He will receive psychological testing while he is there, drug testing. I'm also recommending an apology letter. Your Honor, this is not something the court should expect right away. This is something that's going to be ongoing with the treatment process, and this could take a number of years for him to formulate.
With the counselor to determine when that's appropriate.
That is correct, Your Honor. That is correct. I recommend a formal review hearing in 6 months. I do recommend the blended sentence for Jamarion at this point, that the parents split the court service fee, that he pay a crime victims' rights assessment, and as well as state minimum costs. Your Honor, I've not received anything yet as far as restitution. I have heard the victim's mother speak to that matter, and there may be restitution in the future, so I recommend that this matter remain open at this time.
All right. Fair enough.
Thank you, Your Honor.
Thank you. I want to give counsel as well as Jamarion's guardian ad litem the final opportunity to address the court. Ms. Seidel, I'll start with you.
Thank you. Your Honor, with respect to the recommendations for what I'm going to call for a moment, what I hope is just the interim disposition in this case, a sentence of, I want it to be called a sentence in this case, I agree with the recommendations. Obviously, we do have youth from Kent County that are presently in the Muskegon Youth River Home. I attend review hearings all the time with respect to those, and it's a good program. So I think that's a good placement, institutional placement for the defendant at this point. Your Honor, I do want to say, though, and obviously I can't say anything more really than what the parents did in terms of the agony that this must have caused them. However, I once again would reiterate that while I agree with what's happening with the recommendation today, it is totally, I also agree, we happen to agree with his agreement that it should be a delayed imposition of an adult and not a straight juvenile, because quite frankly, 8 years, as I stand here before the court, 8 years would be the max this court, if you did a juvenile sentence, the max this court could hold him. Quite frankly, 8 years for a first-degree murder is insufficient. Having said that, I'm going to tell you that's my personal view on it. It's a first-degree murder. Connor's never coming home. He could get released when he's 21. I don't think we protect society that way. Therefore, once again, for that reason, we do need I guess I'm going to say the juvenile system might not give the proper punishment. Even if you kept him in an institutional placement for 8 or 9 years, that might not be sufficient punishment. He might not be rehabilitated. And everyone deserves, as the society, and quite frankly, as a prosecutor, I have to look at what's best to society as well. They need to have a message that you don't commit a first-degree murder and then maybe get to walk 8 years later, unless you really, really have shown the court that you never would do something like this again, that you're completely rehabilitated. So therefore, I'm asking the court, just please do not preclude the option for yourself in the future of that, because 8 years just quite simply just might not be enough. Thank you.
Thank you, Ms. Seidel. Mr. Buchler.
Thank you, Your Honor. Obviously, the court's aware of everything that's going on here, the trial. You're as aware of all the facts that have happened as frankly, the counsel are at this point. This is a result of, this is the potential catastrophic result of lifelong abuse. This is why abuse is such a problem in our society. This is what could happen. You couple that with a response from the youth to request appropriate interaction, appropriate intervention, and the futility of that response. And some of the culpability for this matter doesn't rest upon Jamarion, it rests upon the people that were supposed to be taking care of him. And I'm talking about his parents, I'm talking about the authorities that were contacted. That doesn't remove his responsibility, but this is a situation that everyone agrees, and everyone should agree, that we have an ultimate victim here of Connor, and nothing. We all feel terrible, and for what that family's gone through. They didn't deserve any of that. Jamarion, in his way, is a victim as well. So I would suggest to the court that a juvenile disposition could be an appropriate sentence, and at the very least, a blended sentence should be imposed here.
Mr. Reskevich, you, of course, play a slightly different role here. You look out for Jamarion's best interest, and I'd like to hear from you.
Thank you, Your Honor. I guess first of all, I'd like to start by offering my deepest sympathy to the family. And I guess before I make my comments, Your Honor, I have a story and a letter to share with the court. The story is from concerns Reverend Ardo Draper, who is a pastor at Calvary Church. He has become a counselor and a mentor to Jamarion. Reverend Draper has a criminal past that landed him in prison and jail for a number of years. He's turned his life around, and now he's counseling with youth. Jamarion was instrumental in asking the Reverend to go to the detention center and talk with the other boys there and share his story. And he did that, and the boys were very interested and had lots of questions. I think getting Reverend Draper there shows that Jamarion's maturity and the growth that he has experienced at the juvenile detention center. The letter I want to share with you, Your Honor, and the court is from a youth specialist that has been working with Jamarion for the past year or so, and his name is Frank Barones. And he says, I'm writing on behalf of Jamarion Lawhorn. Jamarion has been a resident here in the Kent County Juvenile Detention Center for over a year. I currently work directly with him as a youth specialist. Jamarion is an enthusiastic, friendly, and fun kid. Even when he is having a rough day, he remains respectful and kind to those around him. He brings a fun, loving attitude, smile, and is truly a joy to be around. The odds were clearly stacked against Jamarion at a young age, and I genuinely believe that sending him to prison for life is not in his or society's best interest. I ask you for leniency and consideration for this child who committed an inexcusable act of hatred and violence. I know part of Jamarion's attitude and success within the Juvenile Detention Center is attributed to his structure, security, and safe environment that has been provided for him. Here he is always fed, clean, and has a bed to sleep in. All of these things he never has had prior to being brought to our facility. I've been in this job for over 10 years and have seen the vicious destruction cycle that kids will follow after being in abusive situations. On the other hand, I see Jamarion who fully regrets and acknowledges the terrible crime he has committed and has already been making changes to better himself. Overall, I ask that you please consider giving this kid a second chance at a normal life. He knows he has a lifetime with regret of taking another child's life, but I believe he can and will overcome the society of poverty and destruction that got him there. I would not consider him a threat to society. And I guess now that I want to talk about what I have experienced this past year and a half since working with Jamarion. I was appointed to represent Jamarion last August as his guardian ad litem. I would like to share with the court my impressions and why I believe a juvenile sentence is in his best interest. When I first met with Jamarion, I saw a child with much sadness and hopelessness. I saw the physical scars that will never go away, and I also sensed his emotional scars. Both his physical and emotional scars were from the years of abuse that he has suffered. Throughout this case, I have seen the transformation from a sad and hopeless child to a child that now shows emotion and has a sense of hope. I couldn't even begin to imagine what he had had to have endured in his short 12 years to get to the point of saying that he wanted to die and he wanted the electric chair. It became clearer after reading his case history and how his cries for help went unanswered by his family and by the state. I read where his mother had prior terminations because of children with broken bones and burns. I read about countless child protective services referrals where nothing was done. I read about how the detectives found the home that Jamarion was living in to be in deplorable condition. I read about how he never got the counseling that he needed. And I read about the time with tears streaming down his face, he told the school staff that he was afraid to go home. I read about how his mother and stepfather did drugs and gave him whoopings that left marks. And probably the most tragic event was when there was a CPS referral in 2013. The government's answer was not to open a case and remove Jamarion, but to send him to New York, where he was further abused by his father and his grandmother. He was sent to his father, who was on parole for assault second degree and menacing third degree. The convictions were the result of his father kicking and stomping his girlfriend. These are just some examples of what I believe led this 12-year-old to say that he wanted to die. Jamarion now has a sense of hope with goals of being a writer and a motivational speaker. His cries for help are finally being answered. He is finally getting the counseling that everyone understood that he needed, everyone but his parents. Discipline is carried out in a humane way. It's not meted out with extension cords and whoopings by people hyped up on drugs. He no longer has to live in squalor. He has a bed, he's clothed, and he has 3 meals a day. He finally has positive influences around him day in and day out. While the physical scars on his body from years of abuse and neglect will always be visible, it is my belief that the emotional scars with counseling, education, and stability will heal. Your Honor, I believe in the best interest of Jamarion to be served by a juvenile sentence.
Jamarion, I want to give you an opportunity to speak today and say as much or as little as you'd like.
I'm sorry for my actions. I have been going through lots of things during that month. Every night I have cried for all the pain I have caused throughout the whole process. I have had days without eating because of what had happened. If I could go back, I would stop myself. I now realize the nightmare that you and I have to live with. I don't show any emotion because if I do, I will not stop crying. After the day I was convicted, I did not know how to handle it. All I did was tell myself it was nothing. It was all over and I could never live a normal life. People think I'm crazy, but they don't know what, they do not know me. If I could go back, I would take all the pain and stress rather than take a life. And I really don't understand none of this. I just try to, but I really don't and do not like what I did, and neither do you. And I know what I did was wrong. I just do not understand why I did it. I made a terrible mistake. I just want you to know that I am sorry for all the pain you have been going through. And when I get older, I will help kids not to make the mistake I made and help them become a better person in life so they will not have to suffer the abuse I had to suffer on that day. I was so scared. I was afraid. I was afraid of my stepfather. I wanted to die because I thought there was no way out. I now know hurting someone was not the right answer. I have been talking to a pastor and asked him to talk to the kids in the detention center so he can help them how he was helping me. I'm sorry for what I did. I just wanted you to know that. I just wanted you to know that.
Thank you. A little fast, a little quiet, but I had the opportunity to hear most of it. I hope the rest of you did as well. The court has considered the factors that I've already reviewed as the law requires. The court is also mindful of other circumstances in the case. I am also the judge who is in the Lawhorn neglect case, and I have extensive knowledge of the family from which Jamarion comes. He has been raised in a home with a lengthy history of neglect and physical abuse. His mother had her parental rights terminated over 2 previous children a number of years ago for physical abuse. Child Protective Services were involved with the family in August and September of 2005 and as recently as May and June of 2013. In 2013, Ms. Lawhorn and her longtime partner, Bernard Harold, were substantiated for physical abuse of Jamarion. He was beaten with an extension cord so brutally as to leave permanent scarring on his legs. Then he was moved to his father's home in New York, where he was beaten by his alcoholic paternal grandmother before being returned to Grand Rapids and his mother and Mr. Harold's home. And I must say that the court was not entirely persuaded by Ms. Lawhorn's or Mr. Harold's trial testimony that neither had used physical punishment on Jamarion since 2013. While no child should be subjected to neglect and physical abuse like Jamarion was, the court understands and appreciates that a troubled upbringing is neither a legal defense to murder nor an excuse for violent behavior. But Jamarion was 12 years old when he committed this killing, and it would be naive to conclude that his life experience had nothing to do with his scheme of killing someone so that he would be arrested and executed. The U.S. Supreme Court, Miller v. Alabama, which is sort of the most recent case that the court has decided, a case where a 14-year-old child from Alabama had killed someone, someone who was 2 years older than Jamarion at the time he committed this crime, explained in some detail the reason why we as a society treat juvenile killers differently than adult killers. The court relied on 3 significant gaps between juveniles and adults. First, children have a lack of maturity and an underdeveloped sense of responsibility, leading to recklessness, impulsivity, and heedless risk-taking. Second, children are more vulnerable to negative influences and outside pressures, including from their family and peers. They have limited control over their own environment and lack the ability to extricate themselves from horrific crime-producing settings. And third, a child's character is not as well formed as an adult's. His traits are less fixed and his actions less likely to be evidence of irretrievable depravity. The court further noted that as science has progressed, the science continues to show fundamental differences between juvenile and adult brains. For example, in parts of the brain involved in behavior control. There is a difference between a 12-year-old and an adult making a horrible decision like this. The case is a tragedy all the way around for any of us who have been involved in it. A 12-year-old child brutally murdered at random, a 9-year-old defenseless child, leaving behind a family that aches over the loss of a child deprived of the ability to grow up, to fall in love, and to make life choices for himself. And the 12-year-old killer who did not choose to be raised in an abusive and neglectful home is now faced with coming to terms with the pain he has inflicted, losing his freedom, and losing the ability to lead a normal childhood and adolescence. It is the court's decision to impose a blended sentence in this case. That is a disposition that delays the imposition of a prison of sentence under MCL 712-8.18(1)M. The court places Jamarion on probation under MCL 712-8.18 sub 1 sub B with appropriate conditions. Those conditions include being committed to the Muskegon River Youth Home under MCL 712-8.18(1) sub D. The court reserves and delays the imposition of a prison sentence unless and until a request is made to impose a sentence of imprisonment. As I understand The positions of the parties, both parties agree that it is appropriate to simply wait to determine an appropriate sentence if and when the court is asked to impose such a sentence. I do want to remind everyone, and I'll of course remind Jamarion at review hearings, that violations of probation under the law can result in the revocation of the probation and the imposition of the adult prison sentence. It is critical that Jamarion make his best efforts at the Muskegon River Youth Home to take advantage of the services, to abide by the rules, and to prove to all of us and to himself that he is capable of turning his life around. I believe in redemption. I'm not willing to give that up on a 13-year-old boy at this point. Jamarion, you have the right to appeal your conviction to the Michigan Court of Appeals. The court will appoint you an attorney if you cannot afford one. We are about to provide you with a form to request a court-appointed attorney. You must complete the form and return it to the court within 42 days, or your request will be denied. Ms. Retzkevich, I'd ask if you would kindly make sure that Jamarion completes the form now, so that we do not run any risk of him waiving his appellate rights. Following their meeting with Jamarion after today's hearing, the court will discharge both Mr. Bukaloo and Ms. Retzkevich from their respective roles as defense counsel and guardian ad litem for Jamarion. It has been a difficult case. The court thanks each of them for their service under difficult circumstances. The court will simply appoint a new counsel from our assignment panel to handle the review hearings in the future. Ms. Seidel, is there anything else you would like to bring before the court while we're here?
No, Your Honor.
Mr. Bukaloo?
Nothing else.
Ms. Retzkevich?
No, Your Honor.
Jamarion, good luck. I'll see you at review hearings in about 6 months. I wish you the very best of luck, and thank you all very much. Oh, well, would you just ask for, yeah, okay.
Mrs. Fitzgerald, if you would help him fill this out.
Oh, I'm sorry.
I'm going to go make some copies of just...
I just don't want to write any risk that he waives his
And then
rights.
I will bring you this right back.
We'll go.